thank you very much for giving me this opportunity. Secondly, I'm very grateful to be moderating this esteemed panel of judges where we will be discussing our problem question, which is, are robust reforms the only way forward in Pakistan's litigation landscape? So when I started off doing my research into this topic, there was a few recurring themes, one of them being delay. It seems that Pakistan has a significant number of cases, some backdating over 50 years. I very much enjoyed reading Mr. Justice Saeed's judgment in the case of Pathan, which we will go on to discuss on this panel later, where at the start of a judgment, he made reference to the case of Jarndyce and Jarndyce from Bleak House. And it's fair to say that that very first paragraph in that judgment set the tone for the rest of the judgment which follows. It appears that it is not only significant delays in the existing cases being dealt, but at the same time, there are a significant number of new cases being commenced. I thought it would be helpful to consider a bit of data to the background. So in 2021, there was 4 million new cases filed and 4 million cases were decided across all courts in Pakistan. So it appears to me that as soon as they are dealt with, there's the same amount of number being issued. In 2021, the Supreme Court decided 12,838 cases and received approximately 18,000 cases, resulting in a pending total of approximately 51,000 cases by the end of 2021. Another problem appears to be a lack of judges. In addition to this, it appears to me that some courts are being bogged down by dealing with many different types of cases, which are preventing the key commercial cases from being dealt with. Following Mohammed Zaman Kaisi's comments earlier, access to justice is a fundamental human right where people should be able to have their cases heard. So therefore, what can be done? We've heard many moderators and panelists today talk about the Wolf reforms and how in England there have been many proposals and implementations that have changed the way that the courts have operated. And one of these is the specialist courts that we have in England and Wales. And one of those is the business and property courts, which are the courts within the High Court which decide business, commercial, property, chancery, and other disputes. Effectively, they are specialist lists which enable that each case is specially case managed according to that list to ensure that those cases can progress without delay. Cases are also heard by specialist judges in the area, meaning that there is a continuation for that judge, but also a specialist in that field. We have grasped modern technology, meaning that there is a speedy access to justice. People will attend court from their homes if needed, and indeed, on occasions, judges will also attend court from their home via video link. We also have very important ADR mechanisms in place in England and Wales, where early resolution of issues is a significant factor. And if parties don't try to resolve the issues at an early stage, there may be cost consequences. So taking that all into account, I'm very much looking forward to hearing from the panelists and their existing problems that they have been encountering, and if there is a way that we can make change.